So welcome to this webinar about estate planning. I'm so happy you're here. Before we begin, I just want to let you know that this is for educational purposes, right? Laws change. And it also, another thing that you're attending here to get information about estate planning. Your presence does not create that attorney-client relationship. That happens once we talk one-on-one and so forth. We're going to talk about a lot of things today. We're going to talk about not just estate planning. We're going to talk about the law. We're going to talk about the difference between a will and a trust. We're also going to talk about the human aspect of it, because we're not just dealing with the law, we're dealing with it through our humanity. And this humanity also affects the people that we love. So it's going to have different aspects. Don't worry, I'm not going to use big legal terms that you're not going to understand. I will talk in a way that's very comprehensive and for you to understand. All right, so let me share my screen and let's begin. Slideshow. All right, here we go. Before we begin, so this webinar is about wills, trusts, and incapacity plan. I want to begin to talk about what is estate planning and the specific documents that you need. Now, this is the legal side of it. We're not talking about the humanity side of it yet, but this is the legal side of it. First thing is a will. So what is a will? The legal term is your last will and testament. This tells the court, and I want to stress this tells the court of who you want to give your stuff to. And I'm stressing court because some people think that I have a will, the court's not going to be involved. That is completely false. When you create a will, has to be authenticated by the court that it is legal. And for a will to be valid, it needs specific way to be signed, certain way for to be notarized and witnessed as well for it to be valid in court. The court needs to make sure that this is not fraud and someone just didn't sign your name to a piece of paper and say to give all your stuff to them. So that's the first thing we need. Now, a trust is similar to a will, but it avoids probate. A trust is not necessary, but in some situations, people do need a trust. And I'm going to explain a lot more what a trust is and how it works a little bit later on. So a trust is completely confidential, right? Where a will has to be deposited with the court and it's public record. If you go online and Google Jacqueline Onassis's will, it's going to come up and you can read everything she wrote in her will. Whereas a trust is a private document that stays in the family. And it does work while you're alive and after you're passing as well. Whereas a will only works after you're passing. The next thing you need to have in place is healthcare directives. And there are 4 documents, not just one. So it's your living will. A living will is different than a will. A lot of people confuse them. So the living will document tells people about your end of life decisions, whether you want to be resuscitated, whether you want to, if you become in a vegetative state, do you want a feeding tube to be put in you? And it really helps your family. It helps guide your family as to what you would want to happen. Because it's a very difficult decision for your family. Sometimes arguments happen between siblings of what to do with their parents when they are in this situation. So this one tells the world about your wishes. The second is the HIPAA document. And this allows your family to get information about you from your doctors, from hospital records, and so forth. And that's very important as well. The next one is a pre-need guardianship document. And this document says that if for some reason my family needs to get guardianship over me, I just don't want that judge who has no idea who my family is to make that decision to put a guardian over me. I am naming the guardian right now. And we're telling the judge, if you're going to declare me incapacitated and I need guardianship, this is the person I want to be my guardian. So it's a very important document as well. And the last document is your healthcare surrogate. This is the person that will be your advocate to advocate regarding your health. If you cannot make a decision, for example, if you're in surgery and now the doctor needs to authorization to do another procedure or something happens, this would be the person that would sign off on that. Now, this document is very important. It's a financial durable power of attorney. There are different types of powers of attorneys. Okay. And the one you would want in place is the one that's durable, which means that if you become incapacitated, it's still valid. If it's not a durable power of attorney, upon your incapacity, it's not going to be valid anymore. So this financial durable power of attorney is very important for it, so that if you become incapacitated, someone can step in your shoes and manage your retirement accounts, pay your bills for you. And if that's not in place, then a guardianship needs to be done for you. And that's the last thing we want to do. Guardianship is very intrusive and is also very costly. And the judge may not, if you didn't name a pre-guardian for yourself, the judge may not like some of your family members. If they have some financial problem or if they have too much credit card debt, they may not allow your family member to be your guardian, and they can appoint a court-appointed guardian, which gets paid about $200 an hour to do the work. And this is someone who doesn't know you, is making crucial financial and healthcare decisions on your behalf. So that's something you definitely want to avoid. All right. So I want to talk to you about what estate planning is really about, the human side of it. And while I'm talking about the human side, I'm also going to be talking about the legalities as well. It's an act of love for your loved ones. So I had a situation where I got a phone call from this gentleman, and he was telling me about his sister. His sister lived with someone for 20 years, her boyfriend or her significant other for 20 years. They never got legally married. So Florida does not recognize common law marriage. And he promised her, she had a wonderful relationship with his children. And he told her that upon his passing, he wants her to live in his home. She had hardly any income. He supported her. This was her only home. She could not afford to live on her own. And then, so her brother was telling me that her significant other, her boyfriend, wrote something that she told me he wrote a will. So when I inquired a little bit, I discovered that he just wrote a piece of paper saying that he wanted her to live in this home for until she passed, and then it goes to his kids. Now, that's not a will. That's a piece of paper. And he was telling me now, even though she had a great relationship with his kids, she took care of him when he got sick. She did so much for him. The kids are telling her she needs to leave, and they're taking his house. Unfortunately, in order for the court to validate that piece of paper, it's going to be an uphill battle for her to prove that there was no undue influence on him and that he actually wrote this piece of paper. It's going to be very difficult for her to prove that. And eventually, she's not going to be able to, his kids are going to have a right to the house, and she's just going to be out, most likely living with her brother. If her boyfriend knew that this would happen, there was no way that he would have let this happen. With a heart-centered estate plan, all this pain could have been avoided. So again, it's an act of love for the people that we love, to keep them out of court and out of conflict. It's also about self-care. And I want to explain this because this is I can tell you a very personal story regarding my dad. So my dad was diagnosed with brain cancer last November of last year. And it was very difficult for my family. And I am his healthcare surrogate. So when he was in the hospital, at that time, he was very confused. The cancer was really affecting him. Sometimes he knew my name, sometimes he didn't. Sometimes he would think I'm his little sister. And it was really affecting him in a very bad way. And they wanted to do this procedure for him. And I wanted a second opinion about it. And I told his nurse, no procedure can be done without my consent. I am his healthcare surrogate. I gave the hospital the documents. And this nurse comes and tells me that he can sign the authorization. He looks competent. This nurse only dealt with him. She would go in the room and take his blood pressure and take his temperature, and she would say hello. And my dad was always smiling. So she would walk in and he's like, "How are you?" And he's like, "I'm fine. Thank you for asking." And she was not an expert to say that he had capacity to make that decision for himself. So, of course, I whipped out my paper and I said, I gave these to the hospital and I'm giving them to you. If a procedure is done without my consent, you are going to be liable. See, I'm getting all emotional about it again because it was such a tense moment where this woman who has not spoken to him, asked him the right questions, is making a decision that my father is competent to make. It was a procedure where they would drill a hole in his skull to get a biopsy. And I wasn't sure if I wanted to put him through that right now. I wanted a second opinion and a third opinion. So as soon as I gave her the documents, she took them and she scanned them, she gave them back to me, and she acknowledged that nothing is going to happen until I get involved. I'm the one that's his healthcare surrogate to sign off. So when the nurse's shift changed, I wanted to make sure the second shift knew this. So I went to them and I said, by the way, I'm his healthcare surrogate. They're like, we already know. So it made me comfortable. It made me happy that they talked about me, and I am okay with that. It's so important to have an advocate. And if you don't have an advocate, there are so many things that can go wrong for you. Okay. So part of the estate planning is to create the right documents, put them in place, and name the right people to advocate on your behalf when you cannot advocate for yourself. Another thing I want to talk to you about is control. So I had a woman, she came to my office and she was doing her estate planning. And I always like to know the reason why you're doing this right now. This is an important question. It helps me understand my clients better. So she was telling me that with her inheritance from her father, she bought a house and she was married at the time. And then when she got a divorce, she lost her house to her ex-husband. And she does not want that to happen to her son. So she was creating heart-centered, I'm calling it, and I'm going to tell you the difference between the traditional estate planning, how that failed, and which happened to her, where her father left things to her, and then she used it to buy a house. And because of her divorce, she lost her house completely to her ex. He took the house. Now, we work really hard for what we have. We've worked hard. And we want our children to enjoy their inheritance. But we also don't want our money to go to people that we definitely would not like, this woman's ex, or people we're not even related to. So again, estate planning is about controlling what we have and knowing exactly what would happen after our passing to our stuff and where it would go. Now, I want to transition and go into probate. And when would my estate need probate? A lot of people think of, I created a will, and their mind goes back to the movies, right? When someone dies, an attorney is sitting at their desk in a very big room, gathers all the family and reads the will and says, you get this and you get that. And some of the families are unhappy, some are happy, and so forth. That's not the case. Again, I spoke a little bit about this. A will goes through probate. A probate process is to make sure that will is valid. And it takes 3 to 6 months for the process to move through the court. That's number one. Number two, it's about the attorneys, there is an actual law. It's a statute, Florida statute, that tells attorneys how much they can charge for this, for them representing you in court. And believe me, it is very difficult to represent yourself in probate in court. Even if you go to the clerk's office and say, can you help me? They're going to tell you, get an attorney, because it's really not that easy. And the cost is about 3% of your assets, which is quite, it doesn't sound like a lot, but let's do the math. Let's just say your family home is 600,000 at this time. probably more, stocks and bonds, bank accounts. You may have some retirement. Let's say your estate is worth $1 million. The estimated attorney fees for that estate is $30,000. This is a whole lot of money. Okay. Factoring in fees, we're not factoring in if the attorney needs to help you with insurance or anything else. So it's quite a big bill. Okay. I also want to share this with you. So this organization that does this survey every year, and through their survey, they come up with all these statistics about how your loved ones manage when things are going through probate. So what happens in probate is all your assets are frozen. Anything in your name is completely frozen. So your bills that need to be paid, or funeral arrangements, or if you have a house, the insurance needs to be paid, the water bill, the lights need to be paid, even though you passed away, there's an upkeep that needs to continue after your passing, right? And where is that money going to come from? In probate, everything is in your name is frozen until you get those documents from the court authenticating and saying that you've been put as a personal representative for the deceased. 40 of individuals, well, 52% said that they had to use their own credit cards from their credit cards to pay for the deceased, for the loved ones, expenses and bills. 15% had to borrow money. Okay, took money out from their investments or sold things to be able to pay for these things. 30% said they had to borrow money from friends and relatives. Now, understand these are your loved ones, most likely your children or your spouse, and it depends if your spouse's name is on the accounts. Nowadays, a lot of people have separate assets as well. So what does that do? It really puts your loved ones in a very difficult situation, okay? Because they want to step up and because they care so much, even though you passed away, they want to help out. It really puts them at a disadvantage. This is also was very eye-opening for me, okay? Of individuals are children that handle their parents and step-parents percent. Out of the 63%, 68% of them were females. And I will tell you, I do have a brother, and I will tell you that I am the one that has been doing so much for my parents. I don't know. We are in an interesting, inequality and so forth, but it is what it is. And these are the statistics. How long does it actually take? Because I told you probate takes 3 to 6 months. Okay. To actually finalize everything for the executor, it takes 19.5 months to finalize everything. Okay. It takes a toll on individual who is doing the probate. Okay. 71% of them were actually care. I'm going to put the link for this organization because to download their information. It's very eye-opening. There's a whole lot of things and that statistics that they put on there, which we don't have time for, but I'm going to put that in the chat. I finished this presentation, so you can go and look at it yourself. Other problems that happen. Okay. Let's say you're saying, I want to give to my son 50%, my daughter. What happens if one of your children predeceases you? Well, things are going to go to grandchildren. And grandchildren, what's going to happen to that money? So Florida law says that anyone inheriting more than $15,000, it has to go through a judge, even though the other parent is alive. And the judge is going to oversee this money until this child is 18, and then the child gets all the money at 18. Okay, so many things that are wrong with this law. Number one, if the other parent is alive, the court overseeing everything, the court can even assign another guardian for this money. Okay, the judge has a lot of leeway to your grandchild's money. And when they're 18, they get all the money. Now, we're talking about sometimes there's life insurance involved. It's not like it's getting like I know someone who got $20,000. He dropped out of college. He spend all the money. He thought $20,000 at 18 is a lot of money, these kids, and completely blew the money and then found himself not knowing what to do. And he had to go to college and he lost like 2 years of his life. So 18 is just a number, it's not a sign of maturity. Whereas you can create inside a trust, sub-trust, and a lot of protection in case one of the grandchildren is inheriting now, and it's completely private. A judge does not even get involved in the process at all, even though the money is more than $15,000. So another problem that happens is money gets lost and it's given to the state. So Florida has an account, right, with bank. It's called the Florida Department of Unclaimed Property. And right now there's $2.9 billion in that account. Most of the money belongs to people who passed away and their loved ones have no idea about that he had an account. So, for example, a bank, this bank account that has money in it, no movement has happened for maybe 2 or 3 years. So they may or may not send a letter to the last known address. It's been 3 years, homes have been sold, nobody lives there anymore, and there's no response. So the bank will give the money to the Florida state and it stays there. Okay. Part of a heart-centered estate plan is to get you organized. Okay. I have a spreadsheet that I go over with my clients so that they can put their assets there so nothing gets lost to the state. So this is also a very important aspect of estate planning as well. Okay. So talked about a will, we talked about probate. I want to talk to you now about a trust. What is a living trust and how it works? So I want to use a scenario. Imagine you are going to a supermarket and you decide, I'm going to carry everything in my hand. I don't have a lot of stuff. Let me just take them and walk in. So you get your eggs and you get your milk and you get your things, some bread, and you're carrying it in your hand and you slip and fall. And all these things go up in the air and then they smash to the ground. The eggs are all over the place. You had glass bottles. It's a big mess. Okay. Let's have another scenario. You're going to the supermarket, but you decide you're going to take that shopping cart. You put your eggs, you put all your stuff in there, and you are going to the register, right? And you slip and fall. You're falling, but what happens to your stuff? It's protected. It's inside that shopping cart. Someone else can take the shopping cart for you and buy those things for you. Okay. So think of a trust as your shopping cart or your treasure box, where inside that your assets are retitled in the name of the trust. You create a trust, you choose a name for your trust, and your assets are retitled in the name of the trust. While you're alive, you are in full control of your money. You're also the beneficiary of your trust. So this money is for you. If you become incapacitated, someone steps in to push that shopping cart, to pay your bills, to ensure everything is secure for your benefit. And then upon your passing, things are distributed in the way you want. Okay. And it's completely private. This does not have to be deposited with the court. No one needs to know who you're giving the money to, what the percentages are. It's completely private. And this is in also a completely private matter. I want to tell you that there are so many creative things we can do in trusts to avoid the problems and the stories that I told you. So for example, if that woman that lost her house, her created a life legacy, a trust for her, a sub-trust for her inside his trust, and did not give everything outright to her, that house could have been protected from her lawsuits. So you can think of a trust as you can create your own trust and then sub-trusts inside your trust to protect the money from your children's creditors as well. All right. So I talked a lot about so many things. And I want to discuss with you about traditional estate planning. I talked about heart-centered estate planning. I want to go a little bit of deeper into what things are. Traditional estate planning is you go to an attorney, you tell the attorney, okay, if you're everything to my spouse and then everything to our children, divide equally. And the attorney says, sure, let's do that. You're scheduling another meeting. The next meeting, you're signing documents, you're taking your documents home with you, and that's it. And most of the time when it come and I'm reviewing their documents, I say, do you know what's in your documents? They're like, I have no idea. I don't even remember. Okay. This a document drafter. An attorney is an advocate. You went in to an attorney and you told the attorney what you want, and the attorney said, great, wonderful, let's do that. That attorney did not give you what the of your decisions. They did not give you other ideas. Okay. That is a document drafter. That is not an advocate. That is not a counselor. An attorney needs to tell you what the law says about your traditions, what the consequences are of the decisions that you made. Okay. So traditional planning it work for some people, but most of the time it really does not work for most families, especially families right now. We have people that we have a lot of families where there are children from different marriages, okay, and need to be protected as well. So the traditional estate planning will not work for the families. Money into probate. Again, probate is does 3 to 6 months. And also there's a lot of other things that need to be done to the estate afterwards. So what's heart is heart-centered estate planning. Money is available for your family quickly and privately. Okay. Nothing, no one has to go after your family. When money is distributed, nobody knows who got what. Okay. Making sure individual cannot hurt you, cannot access your accounts. Okay. Identity, people discover, oh, someone's got a inheritance. Let's go after them. Let's try to get their money somehow. No assets are missed and they don't end up with the government. Okay. Heart estate planning with my clients, I stay in touch with them for their lifetime. I'm there to their children move forward as well. I created systems in my plan so that whenever in years, I sit down with my clients and we go over their plan again and say, let's see if it still works. Within 3 years, a lot of things happen. And I talk to people like, when was the last time you spoke to your attorney? It's like, oh, 10, 12 years. I don't even think, a long time. And I even ask them, do you remember what you wrote? They don't even remember who they named as their successors or their representatives. Okay. And these people already have passed and they're still in their estate plan. I empower families to make decisions. So what does that mean? When we have a consultation, when we meet, we what the law says about your situation, about your family dynamics. I empower you to make the right decisions for your family with your specific family dynamics. And I will tell you, I have with so many clients that I have represented, each family has very specific and unique situations. And this is what we plan for. Okay. The family gets to grieve. Okay. When you lose a loved one, it's very difficult because I tell you, I experienced this with my father. He away in February. And the grieving process, it does take some time. Okay. And when the family is grieving and also worrying about money, it becomes a million times difficult for that family. And that's the last thing you want for your loved ones. So how do we get started? First step is not consultation. The first step is a 15-minute free discovery call with me. Okay. And a QR code, I will tell you how you can book this meeting with me. It's 15 minutes with me to see if we're a good fit. Okay. It me get an understanding about your situation. I'm also going to explain to you about my process. And from there, once we decide that we are a good fit, we'll book that consultation. I want to explain to you also about this consultation. It's not a regular get to know you consultation. We already did that in the 15 minutes, and we've decided that, yes, it looks like we are a good fit. So let's meet in person or on Zoom. I do say in the last 3 months, 50% of my clients have been, I do estate planning completely remotely. So I'm licensed in Florida and I've created to do it 100% remote. So that's not an issue if you don't live close to my address, my firm. So once we book this consultation, this is a consultation that I block 2 hours for. Some clients need the full 2 hours, some only need 1 hour. But I don't like to rush people through this consultation. Again, estate planning is not just about the law, it's something very emotional. That's why 70% of individuals in the United States don't have an estate plan because of the emotional part of it. So during consultation, I get to we deep dive an understanding of your family situation and the type of assets that you have and how each asset would pass if you would have passed away yesterday or if you would have become incapacitated yesterday, what would happen to that asset? And upon you getting that clarity, you get to make these choices for yourself on how to move forward from that point. Okay. So because you are here today, I also want to give you a couple of gifts, okay? Because going through my webinar right now, you probably know a lot more than 80% of individuals out there. So I want to reward you with these two gifts. The first gift is for that consultation. Again, I do block 2 hours for. I charge $750 for, but because you are here today, should you want to move forward in our call to do that life and planning session, I'm not going to charge you for that. It's going to be a session that's a question for you. And I'm also, during that life and legacy planning session, that consultation, I will give you $250 off of your estate plan, whatever, whether it's will-based plan or a plan, whatever works for your family. All right, so there is a section for questions, and I would love, we have time for questions. This is the QR code to book this with me. Okay, I'm gonna stop sharing for 1 minute, and I'm gonna also put the link to book. I just want to give you a minute. This is my contact information as well, if you want to take a picture of that to keep. And then I'm gonna stop sharing and put the links in the chat. Okay. Hi, Peggy.
Good afternoon. Hi. We have a question that they want to know if you will send an email with the information, like we use the webinar slides or anything like that.
I
Or do
will
you have a flyer?
send the recording. I will send I can that just
Okay.
send me an email. Let me put my calendar, the link in the chat.
Okay.
Let me see chat. Okay. This is calendar link to book this 15-minute call with me. And I will also share with you that link I told you about to go and okay, it's from empathy.com. Oops, 1 second. Let me put that in the chat. Okay. All right. Okay. Send email. Okay. So I send but give me one day because I need to just to clean and so forth and prepare it. So to those who attended here. Okay. And any other questions? Okay, so there's a question regarding beneficiary designation. People think that so if you have a bank account and you have I put my kids as beneficiaries on that account already. Do I still need an estate plan? This is a really good question. Yes and no. Okay. So answer for an attorney and response. So if you have a beneficiary designation and you become incapacitated, okay, your beneficiary manage your account. They cannot pay your bills. Okay. In order for them to do that, they need you to have an incapacity plan. The beneficiary designation only takes effect after your passing, not while you're alive, even if you're incapacitated and even if you name beneficiaries. That being said, right now, handling a probate case where father passed away, he named his daughter as beneficiary. He only had one daughter. She was his beneficiary. But what happened is the bank was bought by another bank. And when that merger or the acquisition happened, all beneficiary designations were dropped. And she's like, I went to the bank. And this was a big bank that did. I had all the paperwork. My father named me beneficiary, and they said, sorry, you got to go through probate. So it's not always the most secure way of pass through your loved ones. Another thing is that, so if you have two children and they have and grandchildren, and one of them passes and you put them as beneficiary designations on a bank account, if one of them passes, the other sibling gets everything. And if you want things to pass to your grandchildren, it's not going to happen. The bank is not going to do it. Okay. I am not seeing any other questions in the chat. Everything passes through, to clarify, everything passes through probate. I'm not clear on that. So yes, so don't have an estate plan. Yes. So people say, I don't have an estate plan. Actually, you do. The state of Florida has a plan for you. It has a default plan, which is it would go through probate. Yes. All wills through probate. Yes. So all wills go through probate unless, again, so unless you have beneficiary designations. Okay. So that out of probate, but again, beneficiary designation is not 100% secure. Okay. Like I just told you. And also, it does not work for incapacity planning. Yes, all wills have to go through probate. You can't pass anything. If you have an asset in your name, it's going to go through probate, whether you have a will or if you don't have anything at all. And the will is just important because it tells the court who to give your stuff to, because in the will, you're naming individuals as well. Okay, so an estate plan does not. So a trust not go through probate. Yes, it does not go through, you don't have to go through the probate process if you have a trust. But if you have a will, yes, you need to go through, it will go through the probate process. Correct. Any other questions? And if you have a question, please, I'd love to, talk, schedule that 15-minute call with me. I'd love to have the conversation with you. All right. Okay. Wishing you a wonderful rest of your day, a great weekend, and looking forward to speaking with you guys. Take care. Bye-bye.